it's Catherine Cavella from IP Works Law. I just wanted to do a quick video just explaining some things about trademarks, some myths and things you might want to know so that you can make better decisions today about your trademarks. It's one of the things I find myself saying all the time is, I don't have a time machine. So many times people will come to my office with a situation, an opportunity, or a challenge, and I will say, this is what we can do from this point forward. But if I had a time machine 2 years ago, this is what I would have advised you to do, and we would be in a better position now. So I'm doing these videos now, a series of videos now to, maybe I should call it the time machine series, but it's so that your future self will thank you about having more information and making a better informed decision now that will set you up for success in the future. So a couple of things I wanted to address because they come up a lot. Many times people think, well, I don't need to register my trademark because I filed a business registration with the state, so I'm covered. No one else can use my name. That is not true. And I actually have heard people say that a lawyer told them that. Be that as it may, it's not true. I'm a trademark lawyer. Filing your business name with the state, what it does, that's more about the state being able to collect tax returns from you and filing, your annual filings and that kind of thing under your name and not get your company confused in their own books with a similarly named company. So when they say this name reservation thing and they say like that name's taken, you need to take another name, choose another name, that I think leads people to believe that this is the same thing as a trademark registration, preventing someone else from using another name. It has nothing to do with that. It is about the state not getting their own records confused. So you could have, a minor change. Like they might say that name's taken by someone else, but you give us a different name and you present a name that's changed, like one letter is different, and they will accept it. And that's that, you're nothing further is said. They don't, that's the end of it as far as they're concerned. The issue comes when that gives people a false sense of security that their trademark is protected. So for one thing, your business name and your trademark are not necessarily the same thing. This also comes up a lot. So my business name is Cavella and Associates, PLLC. My trademark is IP Works. So, and IP Works Law, actually, also. So those two things are not the same. It doesn't matter. If you're an LLC and you have a DBA, then that DBA is probably your trademark. That's what mine is. So that's the first thing to understand, is that your trademark, your business name is not necessarily your trademark. It might be. Your trademarks are up to you. Whatever you put out there that customers recognize as meaning it's your company providing this service or this good, this product, that is your trademark, whether it's a slogan or a name or a logo or a smell or a color, or it can be all kinds of things. Let's just say it is your trademark, your business name. The thing to understand is, even though you have registered your business name with the state, like I said, that is not the same as trademark protection. And if there are 3 other companies in the same field as you or overlapping into your field that are using a similar name, that will become a problem for you in the future if it isn't now, as you start overlapping into territories and customers start getting confused which one of you they're dealing with. Now, this comes up a lot, especially when the trademarks, when the businesses are very, very descriptively named, like, insert name of town, insert like what you do for people, like Pittsburgh Photocopies. See, this dates me as a child of the 70s. Pittsburgh Photocopies, all right? So if you are Pittsburgh Photocopies LLC and someone else is Pittsburgh Photocopy Store and someone else is Pittsburgh Area Copies, those three are so similar, they would be confusing. The state of Pennsylvania, the Commonwealth, will let all three of those names be registered because they're different enough for their purposes. They are not different enough for trademark purposes. And I will add, they're also highly descriptive. So you can see my other video about strong versus weak trademarks. None of those are very good. They're too descriptive. But I'm using that example here because this is where this business name trademark things crops up a lot when you have very similarly named businesses because they're all very, very descriptive. It can cause a lot of inconvenience to your customers and to you. And at a certain point, it can also damage your reputation if one of those similarly named competitors starts doing bad work for people or starts getting bad reviews. It can bleed over into you while you're just minding your own business, doing great work for people, because someone else with a similar name is getting bashed online. That can hurt you. So this is another reason to avoid similar names, and also to choose a strong and distinctive trademark. So watch that other video to understand what I mean about that. You will be very thankful. Your future self will thank you, I promise. All right, thank you.